In our next segment, becoming a professional athlete is more than just signing that major contract, getting that endorsement deal, and becoming adored by fans around the world. It also means signing some of your rights away, including your likeness and name. But just how much of a pro athlete's image does the team own? Here now to give us more information and an understanding on this complex issue is attorney and legal correspondent David Lesch. Welcome back.
Nice to be here. Summer's over. I'm ready for the fall, which means I'm also ready for a new legal series. We're going to start our constitutional series this morning. And anytime we're dealing with a constitutional law issue, we're always talking about a balancing of rights, right? Usually balancing the rights of an individual against the balancing the rights of society. In today's segment, we're going to talk a little bit about publicity rights with respect to athletes, also with celebrities or anyone else who is not an athlete or a celebrity. And when you're dealing with these types of rights, you're balancing the right of a person to be able to use their own image, their signatures, their statistics, whatever it is that they've acquired to make money, balancing that against the public's right to use that information for their own newsworthy events. Not to make money, but because it's newsworthy. So that is going to be the balance that we're talking about here with respect to publicity rights. Right of an individual to keep their own name, to use their name to make money, or to have nothing done at all with their name, against the public's right to be able to learn more about whatever it is you do. Even if it turns out that they are making some money through it, if it's a newsworthy event, you may not be able to prevent somebody from using your name or your likeness or your voice, and you may lose some publicity rights. Now, let's talk a little about the law. 30 states do have some type of law regarding your publicity rights. By statute, many states give you a right to use your own image, voice, whatever it is. Some don't do it by statute. Some actually follow the common law, which again gives you your publicity rights. Many states do not give you any publicity rights. I'm sure, as you can imagine, the state that does give you the greatest publicity rights, or one of the greatest, is California, because you're a celebrity. So they want to make sure that no one else is using your likeness or whatever it is that you've created as a celebrity. Nobody else wants you to use that and make money, right? So that's very important. In New York, interestingly, the issue as to whether or not your publicity rights continue after death is different than in California. In California, when you pass away, your publicity rights continue for another 70 years, meaning your estate can prevent somebody from using your pictures or anything that you've done to make money for at least 70 years. Right? In New York, when you pass away, your publicity rights end. That's probably why maybe you see on the street people painting different pictures of celebrities and things and selling them and making money of that on these people who are no longer alive, whether it's Elvis or Marilyn Monroe. In New York, your publicity rights end, where again in California, they will keep going for at least another 70 years. These are state laws. Federally, there is no statute that protects you with respect to your own publicity and whether anybody can take it and use it to make money. There is an act, the Lanham Act, and that act prevents somebody from using whatever it is that you do and falsely advertising and thereby hurting your image. That's different than somebody going out and just making money off of your image. So that's a different whole ball of wax. And there has been a movement to try and force the federal government to institute some type of legislation which would protect you on a federal level, but it never seems to get enough steam. So right now there really is no federal statute that protects you with respect to your publicity rights. Let me give you a couple examples of some athletes, celebrities who do not have their courts have held do not have publicity rights in a particular situation. One that came into mind was Joe Montana when he was a quarterback in the Super Bowl. The newspaper had put in a separate spread of the upcoming game, and they used a picture of Joe Montana and they sold it separately. The court held that the Super Bowl was a newsworthy event, and therefore Joe Montana did not have publicity rights with respect to that particular issue, and the newspaper was allowed to sell all the different papers, make money, and not give anything to Joe Montana because the Super Bowl was a newsworthy event. It's always a fine line. Tiger Woods, there was an example where somebody was painting a picture of him at the Masters.
Okay.
and then made copies of it and sold it. Well, the court held, well, the Masters was a newsworthy event of him playing golf at the Masters. He did not have to get paid for all the different posters that were being sold because he was there at a newsworthy event. You understand? Mm-hmm. So that's the distinction. Newsworthy event against publicity right of the individual.
So I know we're talking about pro athletes here. Can we discuss college athletes? Because a lot of times the colleges use the images of, you know, the Cam Newtons of the world to pitch the games, to sell the games. They use those images.
Well, again, those are newsworthy events.
Okay.
When you're playing on Sunday in front of thousands and thousands of people, it's a newsworthy event. They can take pictures and show them and put them in yearbooks and put them in different places because it's an event that everybody wants to see. Now, if they were marketing just him on a t-shirt or pictures of just him and selling just that, not the game, but just his face, and they were making money, the college was making money on that, that might be different. Now, of course, you can always sell your publicity rights. You could sell your right for somebody else to be able to do this. You couldn't do it in college because you can't sell you're an amateur status, but a celebrity can sell their own publicity rights. And many times on the opposite end, the company that hires you and can use your publicity will put in what's called a moral clause, saying that if you do something that we consider to be immoral or hurt your image, we can terminate the contract. So we have the right to your publicity, but if you do something to jeopardize your own publicity, well then we can terminate the contract.
So similar with what happened with Kobe Bryant when the allegations came out of a couple years back,
with
how
the woman, yes. Exactly. That would be a way that many of these companies or corporations that he was pitching products for could let him go because he violated his morals clause. And most athletes have a morals clause. You know, they sell their right to the publicity. But what we're really talking about here is when some people use your own publicity without a contract. And that's really what it comes down to as well. They always argue, well, hey, look, this is for the public. I want the public to see the Kardashians. I want to take pictures and I want to put this out there so we can see what they're doing. It's publicity, yes, and it's their picture. But on the other hand, they're walking around, you know, the neighborhood and it's in public. Yes, it's a picture of them. And yes, I'm making money in my magazine by putting a picture of them, but it's in the public and it's a newsworthy event. You understand? So that would be different. One example of a non-athlete, non-celebrity was a young lady who was under 18. I think she was either smoking cigarettes or doing something that she shouldn't have been doing under the age of 18. And a magazine put her on the cover with a story of this is, you know, the problem with today's youth type of thing. You know, she brought an action, or her mother brought an action on her behalf, and the court said no. The court said this is a newsworthy issue, whether or not children should be doing things that are under the age of 18. So no, we don't have to pay you. Because it was in public. The picture was taken in public. We do not have to pay, you do not have to pay the child for the use of her image in this particular magazine, or you can't prevent them from using it. So these are newsworthy events, and it's always the issue with constitutional law, the balancing of the rights of the individual against the rights of society. In this case, it's the right of society to be able to see what's going on and to see what's newsworthy and see what's important.
So what should we expect with this series after we cover celebrity and athletes today? What should we expect to see next week?
Well, you're going to always see that you never really get a clear answer in constitutional law as to, you know, who really has the upper hand, the individual or the society rights and the balancing of power, whether you're talking about the First Amendment, freedom of speech, freedom of religion, whatever it is, it's always going to be a balance. And that's why I think, you know, this particular series, and I'll also do some of these shows on my own show, Today's Verdict, as well, I think there's such interesting topics because that's what really law is about. It's not black or white, it's gray. And there's no better example of gray than constitutional law. So I'm excited.
Thank you, David.
It's my pleasure. I'll see you next week.